said, I'm an employment lawyer at DJM Law Limited here in Swansea, based out in Llansamlet. Specialise in employment law, and I also lecture part-time at Swansea University on the employment law undergrad module. I've done that for the last 3 years. So specialism in employment law, and say do a bit of lecturing externally as well, part-time. So yeah, thanks again, just to echo what Ed has said initially, thanks to everybody for coming along today and clicking on. And the purpose of the presentation is to work through the new legislation, which, as Ed said, came into force on the 26th of October this year, and dealing with sexual harassment at work. The legislation is the Worker Protection Act 2023, which amends the Equality Act 2010, which some of you might be familiar with, which covers discrimination, all forms of discrimination, that particular piece of legislation. And the new legislation that came in, as I say, at the end of October, amended the Equality Act. So what we're looking at today will be an overview of why this new legislation is significant, what changes it brings in and implements, and what the implications are for you as either business owners or HR managers, HR directors, whatever the case may be. And I think the key point to consider is that, or the most important point to consider maybe, is that the new legislation introduces a new mandatory duty to be proactive, if you like, as far as business is concerned. Whereas previously the position with these types of issues might have been retroactive to a degree, so dealing with problems after they'd arisen. The new legislation introduces a mandatory duty to be proactive, a legal duty now to take reasonable steps to prevent sexual harassment in the workplace and to create a safe working environment. And as far as that second aspect is concerned, you'll be aware, I'm sure, that that's always been the position as an employer, that you have to provide safe systems of work for your staff, and that's echoed and reinforced in this new legislation. So, brief introduction there to what we're, as the slides are concerned. First slide, the introduction and overview. So the objective today, to familiarise you with the new legislation, as I said, to look at the employer duties and obligations, which are clearly key as far as you're concerned, to understand from that point forward what those mandatory obligations, those mandatory duties are, to look at best practice, to ensure compliance, and to ensure and foster a safe workplace moving forward. I've referenced there at the bottom of that slide the Equality and Human Rights Commission checklist for employer compliance. That's an important document, I think, and a good reference point, maybe something to come away from today and to go and look at if you haven't had a chance to consider that, because it's a clear guide that sets out for employers the new responsibilities under the legislation. And it also provides a checklist, which I think, again, is very useful moving forward, and will be very useful moving forward, which outlines the need for policies, the need for clear reporting mechanisms, the need for staff to be trained, and for you to evaluate and address workplace cultures to prevent harassment. And those touch points, I think, are extremely important and can be used as your start point when considering maybe what you need to put in place moving forward at the outset, and how then you move on from that and ensure that you're compliant as you continue. So, the key touch points: policies, reporting mechanisms, training, evaluation, risk assessments, and culture. And that EHRC guide, that was initially, or has been prepared with a view to the hospitality sector. But if you look at that document, and in particular the first page, you'll see that the EHRC comment that it can be used and adapted to suit particular workplaces. So again, I think it's a good referencer, something that's useful to have at hand when you're looking at where you are at present and maybe where you need to be moving forward. And the introduction in that document as well, I think is worth looking at this stage to contextualize where we are and what we'll be considering today as we work through. And again, that introduction re-emphasises that all employers have a duty of care to protect workers. And just reading directly from the introduction here, policies and procedures are not enough to stop harassment from happening in the workplace. Not taking reasonable steps to prevent harassment can have a significant effect on the reputation of the business and the well-being and safety of your employees. Goes on to say your organisation can be held legally responsible for harassment if you do not take preventative steps. So, a good summary there of why it's important to be across these issues and to plan and to make sure you have policies and procedures in place moving forward. And of course, the risk aspect that's referenced in that introduction, and which we'll come to, I'll touch on more as we work through. But the downside of non-compliance is potentially being faced as businesses with claims, which will be time-consuming, which will be costly and damaging to reputation potentially, and also, of course, will have a significant impact on your workforce and the workplace. So, yeah, important. I know I'm sort of front-loading and re-emphasising these points, but it's really important, given that the legislation is now in force, that if you haven't already turned your mind to addressing policies, training, workplace culture, etc., that you need to be doing that as soon as possible. So, definitions of sexual harassment. Again, the legal definition there: unwanted conduct of a sexual nature that violates dignity or creates an intimidating, hostile, degrading, humiliating, or offensive environment. And that's lifted from the Equality Act 2010, which, as I've said, is the relevant legislation as far as protection from discrimination of any kind is concerned. That harassment doesn't need to be intentional. The focus is on the effect that the treatment has on the individual.
Well, Ivan, could I ask you to put your microphone onto mute? Oh, actually, sorry, Paul.
Right, no problem. Okay, so it's the effect on the individual that's important. Doesn't need to be intentional. And we provided some examples there of harassment, whether it be verbal, physical, non-verbal, all covered, all caught within the relevant legal definitions. And what's important there is the understanding the definition, so that if you are in these situations, or when you're looking at policies, procedures, training, whatever the case may be, you're able to identify and address, if needed, harassment effectively. So the strict legal definition is important, but it's the effect on the individual, and be aware that the treatment doesn't have to be intentional. It's the effect is the important aspect there. So the key changes, the reason for presentation today and in considering what we're looking to consider. And as I said, the main change is that you, as employers or your employers, are now under a mandatory duty to prevent harassment proactively. Whereas previously, you might be looking retrospectively and issues occurred and how we addressed them at that point and how we dealt with them. The duty now is to be proactive in preventing harassment. It also covers, this new legislation, third-party harassment. So employers are liable now if employees face harassment from clients, customers, suppliers, contractors coming onto your premises. There's potential liability there if you haven't taken these preventative measures, or in the event of a complaint or a claim being pursued, if the view is taken that the preventative measures you implemented or put in place weren't sufficient. So again, a significant development there, in that you're not only now having to consider the manner in which your employees conduct themselves, but also if you have third parties coming onto your premises, the way in which they conduct themselves as well. And again, as far as that's concerned, that might need to be something that's fed back into your terms and conditions, your policies and procedures, where you engage with contractors or you have suppliers, etc., coming onto the premises, that they're aware that you have these policies and procedures in place, that they will impact on and potentially govern the way in which these third parties conduct themselves. And also then that you make it clear what will happen if those individuals contravene the particular policies that you have in place. Claim periods, the extended claim period as well that's been introduced. Some of you might be familiar with employment tribunal claims and relevant timescales. Generally, the law previously on discrimination claims was that claims had to be brought within 3 months of the act or omission or the failure to act that was being complained about. As far as harassment is concerned, that claim period has now been extended to 6 months. So an individual in those circumstances who feels or has complained that they have been harassed would have then 6 months from the date of the incident to present a claim to the tribunal. And the legislation also introduces increased penalties for non-compliance and in relation to claims. Generally, discrimination claims, just as an overview maybe of cost, I would estimate normally that if you're defending a discrimination claim as an employer, you'd be spending at least £10,000–15,000 on legal fees to run a defence of a case from receipt of the claim to final hearing to trial. Compensation that can be awarded, well, compensation potentially in relation to discrimination claims is unlimited. Compensations awarded based on what's known as injury to feelings, that there are various bandings of compensation, but potentially that compensation is unlimited at tribunal. The other thing that you factor into these types of claims as well is the time and the management cost that goes into defending claims. I would normally give an estimate for a new claim that if you're bringing or defending the claim, that you're unlikely to reach trial for maybe 8 months. And if you're an employer that's defending this type of claim, or any claim at tribunal really, but you can expect to be devoting a lot of management time to liaising with your lawyers, to liaising with me, to prepare documents, to prepare witness statements, to deal with case management orders from the tribunal, and also then to have to turn up at tribunal at the hearing to give evidence. So HR managers that might have been involved in processes, business owners called as witnesses, and potentially the individuals that the complaints have been made against. So discrimination claims. A claimant, an individual that brings the claim, can, of course, name their employer as a respondent, as a defendant to the claim, but they can also bring the claim against the individual that they alleged has harassed them. So, as a very broad overview of tribunal claims, expensive, time-consuming, stressful. So again, the point of what we're working through today is to try and ensure that you, as business owners, HR managers, whatever the case may be, do as much as you possibly can to be compliant with the legislation, and in the event that there are claims, there are complaints, that you can sort of bulletproof yourself as much as possible in that regard by showing that you have engaged and that you've taken these mandatory steps. Okay. So your duties and obligations. The mandatory duty is to take reasonable preventative steps. So what does reasonable mean? There's 3 bullet points there. And again, this feeds back into the EHRC checklist. And this is why I'd said at the outset that I think that's a useful document to consider and a useful start point to reference what these preventative steps look like and what's viewed as reasonable. So what do we have there? Regular training, updated policies which are kept under review, and an established and clear complaints mechanism. So the bare minimum, I think, there as far as preventative steps are concerned. And as far as policies are concerned, a pitch here for me, just forgive this at this point, but if you don't have policies and procedures in place, we can provide them, I can draft them, work through what you need in relation to your business and how that fits together. But you need a clear policy on prevention of harassment, sets out the business's position, sets out that you understand your mandatory obligations and what you will do to make sure that, as far as you possibly can, that harassment doesn't occur, and then the steps that you'll take if complaints are brought. Regular training, well, again, similar to what we're going through now, that staff are trained and they're aware of the effect of the legislation and that harassment won't be tolerated, and what happens if there are complaints and how those will be dealt with. And again, as far as training's concerned, just as a side issue there, to make sure that anybody that's taken through training signs off on it. So in the event that you did have a complaint or that a claim was forthcoming at some point, you can produce not only the policies and procedures, but you can produce a record to show that individuals were trained and that you kept on top of it. And as I said there, that the policies and procedures were regularly reviewed, annual training was given, whatever the case. So not only having the policy in place, but also a record to show that training was delivered and everybody was signed up to the training and the policies. Clear and accessible complaints, I think that's important, and also stressing within that any individual that comes forward and brings a complaint won't be treated any differently. They won't be treated to their detriment as a result. If they want anonymity, then potentially the anonymity will be protected as well. But a clear mechanism to show how complaints can be brought, how they'll be dealt with, and how individuals be bringing those complaints will be protected as well. And as far as the business is concerned, we need to appreciate as well that this concept of vicarious liability that I flagged up there, in that employers can be found to be liable, accountable for actions of their employees unless they can show that those preventative steps have been taken. So again, it's important because you as a business owner can be held responsible for your employees' actions. And again, those third-party obligations are important as a new strand, if you like, to this legislation. Within your policies and procedures, within your training, address the fact that harassment from non-employees is also covered by the legislation, and in doing that, including that in your policies, including that in your training materials, and as I've said, just taking that further and extending that slightly, covering that off in the agreements, in the contracts, in the written documentation you have with suppliers, contractors, clients coming onto your premises, that harassment by third parties won't be tolerated either. So again, what we're looking to do there as much as we possibly can is to avoid any liability in that regard by showing that we took those preventative steps at the outset. Best practice. This comes back to fostering safe workplace cultures. You as a business need to be showing a zero tolerance to harassment. You've got to actively commit to that. How do you actively commit? How do you show that you've done that? Again, I'm re-emphasizing these points from the checklist, but policies in place, regular training, staff being made aware generally that this type of conduct won't be permitted. Within that, and this comes back to that complaints mechanism that I referenced in the last slide, but ensuring that or encouraging employees to report concerns without fear of any retaliation or retribution. That's exceptionally important, I think, that there's a culture of being able to report without fear of any comeback in having done so. That really needs to be front and centre within policies, within training, within procedures. Okay, and again, moving forward, once you have the policy in place, once you've set up the training, once staff have signed off to confirm they've had that training, make sure that you undertake regular policy reviews. I see it in lots of cases, lots of claims where training is given, staff sign off, and then the handbook, the staff handbook, whatever the case may be, is consigned to a cupboard somewhere, and it's not looked at again for years. And then at some point, there's a complaint, there's a claim, and the business references back to that document and says, okay, well, look, we trained on this in 2020. Invariably, the judge and the claim being brought, and the counsel, the barrister on the other side bringing the claim will say, well, okay, when was that updated? Our staff kept up to speed with this. You trained 5 years ago. You haven't done that since. Is it still front and centre in employees' minds as to what the business obligations are and how they should be conducting themselves? So again, ensure regular reviews, ensure that's ongoing. And also within your policies and procedures and your initial setup and how you deal with training, stress the value of that, stress the value of education to employees on understanding what the definitions of harassment are, understanding reporting procedures, and in being able to report inappropriate behaviour. And that same consideration that applies to individuals that might be bringing complaints or claims, that they won't be treated to their detriment and they shouldn't fear any retribution. That equally applies to other members of staff who might witness that type of behaviour and might feel compelled to come forward and speak to you about that, but might think, well, okay, if I do that, then maybe I'm going to be in the firing line, or I'll get myself into trouble again. stress to those individuals that they'll be treated in the same way as an individual that brings a complaint directly. They'll be protected, there'll be no retribution, they shouldn't fear or be afraid of any retaliation in that respect. Reporting channels, reporting mechanisms. Firstly, they should be accessible, and it should be clear, set out quite clearly to employees what the relevant channels are. Do you set up anonymous hotlines? Is there an app that you use to report, or is there a designated HR contact that is named and that individuals are then aware they can come forward and speak to in those circumstances? Again, make it clear, set it out quite clearly in your policies and procedures, so that in the event of a claim, in the event of a dispute, you can point back to that and say, well, look, as far as preventative measures are concerned, we acted reasonably. We've got policies and procedures in place. We had regular training. We updated the training. And lines of report, lines of complaint were quite clear, set out in the policy, referenced in training, and refreshed as as time went on. So again, make it clear to individuals what the process is, what the mechanism is for moving through complaints, and be able to point to that documentation if you're ever involved in a dispute. Whistleblower protection, I won't touch too much on that, but yeah, the principle as far as whistleblowing is concerned, protected disclosures, if you've ever come across those phrases, is if you whistleblow, you're protected then from being treated to your detriment as a result of whistleblowing. Same principles apply here. I keep stressing that point, but it's important. Support resources, if you have employment assistance programs, EAPs, then again, can you build in something within that allows employees who brought complaints to access that type of support resource? Is there counselling available? Anything of that kind? Preventative steps, you're building what you're putting in place there. So if you have the scope, or if you have those EAPs in place, or if you have independent counselling helplines, build that in as well if you can for victims here to be able to access those services. And again, make sure that anybody bringing a complaint or coming forward with this type of issue feels supported. And you can reference that in your policies and procedures as well. That the business will support and does offer whatever the add-ons are, EAP, counselling, whatever the case may be. But victims, individuals bringing complaints will be supported throughout the process, and the business will do as much as it can, not only to address the complaints and deal with the issues, but also to support the individual moving through. Remedies, I've touched on these already. This is the scary aspect, if you like, for employers, where potentially complaints are followed through to the employment tribunal. Again, as I've said, the individual, the employee, the victim in those circumstances would have 6 months to bring a claim. Compensation, potentially unlimited in certain circumstances. As I've said, claims will be presented to the employment tribunal, and the downside of being involved in that process, and this advice I give generally to anybody looking to bring or defend a claim: be prepared for time, cost, and stress. So if you can avoid that, if you can have steps, policies, procedures in place to avoid that as far as you possibly can, that has to be the way forward. Because once you are into that tribunal process as an employer, once you receive the claim thrown through the post and have then a month to defend the relevant claim, as I say, you're committing to time, cost, over a significant period of time, 8 months, 12 months, whatever the case may be. But what we're looking at today as I've said, is trying to protect ourselves as far as we possibly can from getting into that position, to ensuring that we're compliant with the legislation, compliant with the preventative steps that we need to introduce and that we need to have in place moving forward. Okay, so on that point, preparing for the future. If you haven't already started doing that, if you haven't already addressed these issues and got policies and procedures in place, what's the action plan? Well, policies and practices. Sexual harassment policy has to be the starting point and has to be in place as soon as possible. Make sure that staff are aware that that policy has been introduced, what its effects are. Make sure, as far as you possibly can, that you can confirm that the policy has been released and received by individuals. Training programs doesn't need to be that initial training doesn't need to be more than the sort of 45 minutes, 1 hour that we've run through today. Risk assessments is an interesting one. The suggestion is that you should conduct workplace risk assessments to identify vulnerabilities, and you'll see commentary and report in this area, maybe on situations where you potentially can identify that harassment could take place. And the key one that I've seen that comes through from lots of literature is workplace functions, particularly relevant at present, I guess, now that we're entering the festive period, and office parties and whatever else. Those are perhaps scenarios where harassment might be more prevalent. And so in those circumstances, again, if you were challenged in relation to an incident that occurred in some marketing scenario or an office party, an office function, if you couldn't show that as part of your risk assessment, you'd identified those scenarios that could be problematic in relation to the legislation, and you hadn't taken steps to address the issues that could occur, then you could open yourself up to claims rather, and those arguments that you've fallen short maybe of the preventative measures that you should put in place. So, again, if you had a policy that covered workplace functions so that staff were aware of what was expected of them, that, even though these functions might be outside of work, that they're still subject to work policies and procedures, and that the level of conduct expected of them doesn't differ than that it would in the workplace. Those are the types of things that you should be putting in place in advance of events. And also, as I say, maybe if you have individuals, staff that are going out generally on marketing events or client development events, that they're aware also that the legislation applies, rules as to conduct apply, and that there could be disciplinary issues that come from breach of those obligations. And again, equally, that if individuals have complaints arising from any of those particular scenarios, that they can be brought under your policy and procedure, and that they will be protected and supported as you work through. So, that's a very quick sort of 35, 40-minute work through of the legislation, the new concepts that are introduced, and where we find ourselves today. And the whistle stop, the bullet points, I think, are that mandatory obligation on you as employers to take preventative steps, preventative measures. What do those preventative steps and measures look like as a bare minimum? Having a policy in place, having training in place for staff to understand the policy and its ramifications for them, keeping that training updated. Clear reporting mechanisms, so staff are aware, employees are aware of where they can report, how they can report if they have these issues, and offering support over and above then the actual reporting mechanism. And also, I think a risk assessment generally for your businesses as to where these potential trigger points may occur, that you've assessed, to show that you understand the duty to provide a safe workplace culture, and that there are perhaps scenarios where issues might occur, and steps then that you've taken to address workplace functions, as I said, office parties, marketing, client development, whatever the case may be, that you've applied your mind to that, and that you've ensure that as far as you can that harassment is prevented. Again, that key, the proactive element of prevention, rather than, okay, we've got a complaint, how do we deal with it? And again, just touching back to the EHRC document, the checklist that I referenced at the outset, that's important, I think, because it's a good guide. It sets out a clear process, a clear procedure. So well worth a look at if you haven't come across that already. And yeah, that concludes, I think, my presentation. Covered a lot of ground. I think those 3 or 4 bullet points I just touched on are the important ones to take away moving forward. Any questions generally now, please feel free to fire away. And more broadly, if there's anything you as businesses need or anything you want to touch on as far as these issues or anything that's been out for them are concerned, then yeah, I'm happy to deal with them within my day job, as it were, and I can let you have email addresses and whatever else for anything you need over and above that.
Thank you very much, Paul. That's been incredibly informative. I appreciate you taking the time to take us through that. I have a couple of questions myself, but I want to open it up to the floor first, just in case there are any burning questions from the participants that are with us. So if you have a question that you'd like to ask Paul, please pop your hand up, and I'd be quite happy for you to take the floor. Okay. So I think that's hopefully a good indication of the fact that you've got across the detail, which is much appreciated. Thank you. A lot of key messages in there, Paul. It's a big sort of impact on workplace culture, I guess. But one thing I just wanted to ask about was about lone workers, in particular, company representatives who may go abroad or who are attending functions in isolation. And therefore that sort of risk assessment that should be taking place or could be taking place would have to sit with the individual, and therefore it's something that I guess would have to be shared across the whole organization, that people need to be aware of that sort of risk assessment process, and it's not necessarily a managerial thing. Would that be fair to assume or not?
Well, I think to a degree, in as much as the duty is on the employer. So first and foremost, it's for you, if you have lone workers, to assess what the risks are, and then I think to include that within policies, preventative policies, etc. But then to discuss with individuals that go off and deal with customers and clients in those scenarios. And the important aspects of that would be making them aware that there are, if ever they feel vulnerable in those circumstances or have issues, that it comes back to clear reporting, support, whatever the case may be. So, we as a business appreciate that as far as the legislation is concerned, these are scenarios based on our risk assessment that could create issues. You're placed in that particular situation, and if you have complaints, then look, this is how we deal with it. Very clear. As to maybe how you communicate that to third parties, again, I I've given that some thought, but whether that is something that's worked generally into your T's and C's, your contractual documentation with your clients, your suppliers, etc., to maybe stress that we as an organisation, take our obligations under the new legislation seriously, and you will of course be aware that the legislation covers not only our employees but third parties as well. We have policies and procedures in place to prevent and to protect our employees, and you're just front and centre then in your dealings with suppliers, customers, clients, whatever the case may be. But you're also reinforcing to your staff that you offer as much protection as you possibly can under the legislation, and that if they are in the unfortunate position where they have to make a complaint, it'll be viewed seriously, it'll be dealt with properly, and they will be supported throughout the process.
Yeah. Okay, thank you. Are there any further questions for Paul? Can I just check, Paul? Oh, Andrea. Question for Andrea, who is currently on mute.
Can you hear me now?
Yes. Yeah.
So, hi, Paul. How are you? All right?
Yeah, I'm good. Thanks. How are you?
Yeah, good. Thanks. Just a quick question in respect to company websites where you can have feedback, questions on our website through various different means. Should we put a disclaimer on that as well to say that we are now, we've always been fully compliant, but that we are. So put it on the website as well.
I would. Yeah. I
Okay.
don't see that there's any harm in that at all. That, and from that preventative aspect, again, I think that's something that you should be doing, because again, it's front and center.
Yes. Okay. Brilliant.
Yeah. So I'd certainly be looking to include that.
Okay. Thank you very much.
Okay.
Thank you, Andrea. And just very quickly, that workplace checklist from the EHRC, where would that be available? Sorry, just.
If you can Google that, the EHRC checklist and action plan on sexual harassment at work.
Okay.
And it'll turn up a link to a PDF document. As I say, that it's focused on the hospitality industry, but it's equally applicable for any employer, I think. And it's a good checklist. It runs to about 9 or 10 pages, but that would be very useful to have at hand, and to consider the checklist when you're looking at implementing policies as well.
Yeah, fantastic. Thank you. And I think also I can imagine having your telephone number on speed dial, particularly as we approach Christmas function season as well, could be quite useful.
Yeah, well, I've always been quite keen on workplace function policies generally, just to remind employees that even though it's outside of work, it doesn't mean that you're not subject to the same considerations as to conduct, and just reminding staff of obligations. It can be difficult, and we see lots of cases where scenarios where perhaps you offer a free bar or whatever the case may be. That makes it a bit more tricky. But I've always been very keen in advance of summer parties or Christmas functions or whatever the case may be, to have these policies out on email and to say, look, okay, just as a reminder, this is our position on these types of functions and how you should be conducting yourselves, and what happens if there are issues. And so I'd always be flagging those up in advance.
Okay, thank you. Any further questions for Paul? Okay, in that case, Paul, thank you very much for the very timely presentation. Can't help but think that safe workplace culture, safe workplace functions is absolutely critical to help get the best out of your resources, isn't it? So it's been really helpful to take us through that. Thank you.
No problem at all.
On behalf of Swansea Council, Paul, thank you very much. Appreciate your insight. And to all those who have joined us this morning, thank you for taking time out of your busy schedules. Thank you once again, and thank you very much for everybody attending. Look forward to seeing you all again soon at some point.
Cheers. Have a good day.
Thank you. Bye.
Bye. Bye.